And now it's time for Illinois in Focus with the Center Square Daily. I'm your host, Greg Bishop, and today at the Illinois Supreme Court in Springfield, a couple of different cases being debated in front of Supreme Court justices concerning Illinois' firearm owner's ID card. This is a card that's required by Illinois residents to be able to purchase and possess firearms and ammunition. And the card itself, several requirements. You've got a $10 fee, a recent picture, and a valid driver's license. And those things seem to be easy to obtain, and you can go get a valid FOID card to then be able to purchase firearms and ammunition. But there are some other provisions that Illinois State Police spell out in their rules and the eligibility to get one of those FOID cards. Among those are you cannot be a convicted felon under the laws of any jurisdiction. State police also spelling out that you cannot be adjudicated a, quote, mental defective. Also, you can't be a mental patient in an institution for the past 5 years, not intellectually disabled or developmentally disabled in the past year, and also not addicted to certain substances, plus a whole host of others that you saw there in the graphic, spelling out who is eligible for a firearm owner ID card. Now, there have been several cases brought up to the Illinois Supreme Court challenging the constitutionality of requiring somebody have a piece of identification provided by the state that allows you to purchase firearms and ammunition. As the Second Amendment says, a well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. You can see the questions being raised by Second Amendment supporters that having a state-issued ID as a requirement to obtain a firearm is an infringement. We've seen multiple cases in front of the Illinois Supreme Court challenging this, but each time the Illinois Supreme Court's taking procedure to essentially remand cases back to the lower courts for them to deal with certain types of questions. Well, today, in front of the Illinois Supreme Court, they did hear a case concerning individuals who are challenging the FOID statute. And Elizabeth Cook, an assistant appellate defender for James Benson, she spelled out in her arguments in front of the Illinois Supreme Court that the FOID card does not match up with the Second Amendment right to keep and bear arms.
Under the framework announced in Bruin and Rahimi, the burden is on the state to point to a historical analog that is similar in the same purpose and the same manner that it regulates firearm possession. Those people who are law-abiding definitely do have Second Amendment rights. But in fact, as we can see from the example set in Rahimi, the court considers all American citizens to have Second Amendment rights, and then will conduct the historical analysis to determine whether the regulation at issue is based in history and justified by the policies that would have motivated people at the time of the founding. Permanent prohibition on Benson's firearm possession with criminal penalties for violations based on a prior conviction for nonviolent conduct is incompatible with our nation's historical tradition and thus violated the Second Amendment as applied to him. The legislative scheme outlined in the FOID Card Act, a presumptive lifetime ban on firearm possession subject to inexact criteria and complete government discretion, has no historical analog.
Now, legal documents show that from a bench trial, James Benson was found guilty of 1 count of reckless discharge of a firearm, 1 count of unlawful use or possession of a weapon by a felon, and 1 count of misdemeanor domestic battery. Benson was sentenced to 4 years in prison, and the direct appeal from the judgment is what the court was taking up. No issue being raised about the charging instruments in that case, but the plaintiffs there, the defense in this case, saying that the recent rulings out of the U.S. Supreme Court are highlighting that, in their arguments, the FOID card in Illinois is unconstitutional. But the state being represented by Garson Fisher as the Assistant Attorney General, he says that the U.S. Supreme Court has greenlit states like Illinois that have a similar type of identification process for gun owners.
Both Heller and then McDonald explicitly held that prohibitions against felons possessing firearms are constitutional. This court in Burns, relying on those opinions, reached the same conclusion. And that conclusion was actually reinforced in Bruin. when the court reaffirmed the holding of those earlier cases that the Second Amendment protects the rights of law-abiding citizens to possess firearms. Now, that category, law-abiding citizens, necessarily excludes all felons. Now, my friend says that the mechanism in the FOID Card Act itself is unconstitutional under Bruin, but Bruin is actually inapposite to that provision. What Bruin is talking about is the presumption that ordinary law-abiding citizens have a right to possess firearms. And in footnote 9, it recognized that shall-issue licensing regimes, including Illinois', are constitutional because they do presumptively allow law-abiding citizens to possess firearms.
Now, the Illinois Supreme Court took that case and a second case concerning Illinois' firearm owner ID card under advisement, which means it could be weeks to months before we find out how the Illinois Supreme Court rules on this. But you also have to consider other cases that are working through the state judiciary, including another case concerning a challenge to the constitutionality of the firearm owner ID card expected to be heard by the Illinois Supreme Court next week. Now, that's the state courts. We have not seen any movement on challenges against Illinois' gun and magazine ban. You have the Viramontes case out of Cook County, which includes challenging the state's gun and magazine ban of semi-automatic firearms and magazines over certain capacities. Still in front of the U.S. Supreme Court. Whether or not they're going to take that case has not been revealed. But then you've also got the Barnett case, which has a Southern District federal judge in Illinois determining that the state's ban is unconstitutional. That case has been heard by the appeals courts, but that was back in September of 2025, and it's been months since gun owners have had any certainty on what's going to happen with that case. So still plenty more to come when it comes to litigation against Illinois gun regulations and whether or not those are constitutional. So that is Illinois in Focus here for the Center Square Daily. From my studio in Central Illinois, I'm Greg Bishop, and join us back here Wednesday for more stories impacting you, the taxpayer, from around the country, only with the Center Square Daily.